Thank you. Okay. Okay, so today is our last topic, standard and burden of proof. First question for the day, what is burden of proof? So the concept burden of proof, or in Latin known as onus probandi, is the obligation to prove one's allegation which are presented in the legal action. So it's a obligation, it's a responsibility, it's a burden, it's a task, a duty for one, okay, to prove their duty in court, okay, whether to prove against the allegation or to deny the allegation. So all the party appear in court has such burden, okay. So that's the concept of burden, onus probandi. You refer to section 101. Section 101 talk about this burden of proof, beban bukti. He said that whoever, subsection 1 to 101, subsection 1, whoever desire any court to give judgment as to any legal right or liability dependent on the existence of facts which is asserted must prove those facts. Barang sesiapa berkendakkan mahkamah memberi penghakiman terhadap apa-apa hak atau liability di sisi undang-undang dengan berhubung padanya fakta-fakta yang tegaskan olehnya mestilah membuktikan fakta-fakta itu ada. Okay, when a person is bound, subsection 2 pula, when a person is bound to prove the existence of any facts, it is said that the burden of proof lies on that person. Apabila seseorang terikat untuk memberi apa-apa keterangan, maksudnya bahawa dikatakan bahawa beban terbukti adalah terletak kepada orang berkenaan. So, based on section 101 this, section 1 and 2, is clear to us that there are two type of burden. Okay, burden of proof. Satu kita panggil evidential burden, satu lagi kita panggil legal burden. Okay, evidential burden means, which I like, to introduce evidence, and legal burdens means to establish a case lah. Okay, so you introduce evidence, number one, that's burden number one. So everybody have a same duty lah, whether the prosecutor or the accused or whether the plaintiff or defendants, okay, they have a duty to support their case with evidence. Okay, so that's why this topic will be located at the last part of evidence. So that, because it's about presenting evidence. Okay, so you have learned evidence since last semester. Okay, you know by now what is evidence. You know a little bit how to authenticate evidence. Okay, and the relevancy of evidence. So now, okay, if you have a case in court, every case must be supported with evidence. Okay, it's not enough for you to bring evidence, but you must convince the court to accept your evidence. Convincing the court is the legal burden to establish the case. Okay, so don't worry, we're going to discuss one by one about these two aspects of burden of proof. Burden to bring evidence and burden to establish a case, as mentioned under section 101 just now. So basically we have a two burden. We have evidential burden. Dalam bahasa Melayu kita bagi beban keterangan. Number two, kita ada legal burden. Kita panggil beban undang-undang. Okay, beban keterangan dengan beban undang-undang. You refer to the case of International Times against Leong Ho Yuen. Okay, 1980 to Malayan Law Journal 86. A good judgment by Tun Saleh Abbas. He said that for purpose of this appeal, it is necessary to bear in mind the distinction between two senses of burden of proof. Okay, itu dia. So what are they? The first sense signified by the expression burden of proof such as referred to in section 101 of the Evidence Act is the burden of establish a case. Second sense refer to the onus of proof. On the other hand, relates to the responsibility of adducing evidence in order to discharge the burden of proof. Okay, the first sense is to bring evidence. The second sense is, okay, not only to bring evidence, but also to convince the court, okay, to accept all the evidence we tendered, okay, to the court, okay. So we go one by one. What is evidential burden? Beban keterangan. So evidential burden is a leading evidence. It's a burden of leading evidence or lighter burden. Dia beban yang ringan. And this kind of burden always shift from one party to other party. Okay, a party may submit evidence that the court will consider prima facie proof of some state of fact. This creates an evidentiary burden upon the opposing party to present evidence to refute the presumption. Okay, itu dia. Burden is a lighter burden lah, beban yang ringan ya. And it always shift to one party to another party. What do you mean by beban ringan? Apa yang maksudnya shift to one party? Of course, in all cases, both party have a right to bring evidence. That's why both party have a right to produce their evidence. That's why it shift from one side to another. You bring your evidence, then I bring my evidence. Then you bring your evidence, I bring my evidence. That's why it shifted. It's lighter burden. Why is it called as a lighter burden? Beban yang ringan. I know, maybe it's really easy to bring evidence to support certain kind of a case. Okay. So as we discussed last semester, what is evidence? Section 3 define evidence as any kind of evidence. Evidence includes. So it means that anything can be an evidence. Okay, I don't know. Some of you ask question. Yang ni boleh jadi evidence tak? I mean, kita dah belajar kan last semester kan? Mestilah boleh. Section 3. Okay. To some extent, even hearsay also can become an evidence. That's why we learn about hearsay evidence. But it's not a good piece of evidence. Okay, most of the time being rejected. But in some situation, there are some possibility whereby hearsay evidence also can be admitted lah. Kita dah belajar kan exception. Apa tu? Res gestae, dying declaration. Okay. Etc. etc. So this one known as a lighter burden. This is people's view lah. People thought that to bring evidence is an easy thing. That's why they call it a lighter burden. And this kind of burden always shifted from one side to another side because every side has a right to bring forward their evidence. Okay, that's why it shifted. Okay, prosecutor, you bring your evidence first, then rebut by defense counsel. They bring their own evidence. Same goes in civil case, plaintiff and defendant. Selalu berubah-ubah. Okay. Yang satu lagi legal burden. You can see the photo there. There's a big head on the top of the solicitor, the lawyer. So this is the most difficult part. Okay. Tadi evidential burden is a lighter burden. This is normally known as a heavy burden. Heavier burden. Beban yang berat. No point you bring 1,000 evidence but you are unable to convince the court. So it's not about the issue of bringing evidence, evidential burden. It's about also convincing the court to accept your evidence. How to convince the court? That's a very tricky question. It's very subjective in nature. It depends on the nature of your case. Okay, criminal is totally different from civil. Okay, okay. So how to really convince the court? If you ask me, make sure the evidence is very strong evidence. It's a best evidence. Okay, relate to last semester topic. So this topic, standard and burden of proof, our last lecture for today is a summary for all topic we have learned from last semester and together with this semester. That's why I repeat again all what we have learned because it's interconnected. Okay, make sure your evidence is how to convince the court. Make sure your evidence is strong. Make sure your evidence is relevant. Make sure it's the best evidence. Make sure it's a convincing evidence. Make sure that you authenticate your evidence properly lah. Yang itu saja, how to authenticate a documentary evidence, how to authenticate a testimony from witness last week. Okay, so that's how is it. Okay, once the burden has been entirely discharged to the satisfaction of trial facts, the party carrying the burden will succeed in his claim. Okay, and this kind of burden is not shifted. Tadi evidential burden selalu berubah-ubah. This kind of burden, not only his heavy burden, but this kind of burden is not shifted, tak berubah. Dia selalu stay dekat orang tu je. Kalau dekat prosecutor, prosecutor je. Defense counsel je. Dia tak ada shifted. Okay, inilah duty prosecutor untuk prove the case. Inilah duty defense counsel untuk prove the case. Sama jugalah dengan plaintiff dengan defendant dalam civil case. Apa maksud dia? Okay, legal burden. Inilah maksud dia. Very simple. Okay. So dalam civil case, dia punya legal burden would be imbangan kebarangkalian lah. Balance of probability. Okay, plaintiff must bring their case. Okay, must prove their case on balance probability. Same goes with the defendants. Must prove their counter argument on balance of probability. Okay, but it's depend on the nature of a civil also, civil case. If the more serious civil offence, the more higher balance of probability. Sebab balance probability pun ada dia punya standard dia tu. Okay, ada yang low standard, ada yang standard, ada medium standard, ada yang high standard of balance of probability. Depend on the nature of or the severity of the civil case. Okay, dalam kes-kes civil ni ada jenis tahap-tahap yang serius, kurang serius, tak serius langsung, bergantung lah. Okay. Dan kalau kes jenayah, I think semua dah tahu kan, BRD lah, beyond reasonable of doubt, not beyond shadow of doubt. Beyond shadow of doubt, macam dalam Islam tu dia dah belajar apa konsep dia? Yang atas sekali tu, yakin yakin. Okay, impossible you have a yakin in every situation. Impossible. Okay, buru-buru zun je, zun adalah ghalib. Anyway, if I not mistaken. Di luar keraguan munasabah lah, BRD. Okay. So dalam kes jenayah, siapa yang ada to prove a case, siapa yang ada legal burden to prove beyond reasonable doubt? Is it the prosecutor or defense? Anybody know? Dalam kes jenayah. Who best?
Prosecutor.
Prosecutor, correct. Untuk defense pula, apa dia punya burden? Anybody know? Legal burden dia? Is it same like prosecutor?
No.
Apa burden dia?
Defense counsel.
Defense counsel, apa dia punya burden? Quantum of proof dia?
Balance of probabilities.
Correct. It's not same like prosecutor. Belajar kan dulu kan dengan siapa yang mulia Raja Razif Okay, defense kan, banyak defense kan. Okay, so it's not same like the prosecutor lah. Okay, that's why I said just now, tadi slide tu apa dia cakap, legal burden obligation remains on the single party. Maknanya dia tak ubah-ubah tu. Okay, prosecutor itulah dia. Beyond reasonable doubt, defense counsel ni ada balance of probability. Kalau you ingat lagi last semester I inform you masa we talked about the first chapter you ought to refer to our evidence acts. Anything happen, anything you want to talk about evidence, you ought to refer to our evidence acts, not common law cases. Saya ingat tak kes Jaya Sena tu So that's a very good case when we talk about this thing. Okay, in this Jaya Sena case, he referred to Wilmington case. We talk about standard and burden of proof. Okay, what happened was he will refer to Wilmington punya case. In that case, English case, what happened was there was a similar quantum of proof, not only for prosecutor but also for defense counsel, which is on beyond reasonable doubt. But the court scolded Jayasena case there, said that there's no need for you to refer to English cases. You just refer to our section 105 of Evidence Act. It clearly may indicate that for the burden of proof for defense is not as similar like prosecutor. It's different, which is on balance of probability. Okay, relate back. What's semester? So this topic, standard and burden of proof, our last chapter for today is a summary for all the things we have learned for evidence since last semester until today. Okay. Standard and quantum of proof. So we finish about burden of proof. Now we move about the standard. Standard of proof. Standard of proof apa? Tahap pembuktian. Quantum of proof. Okay. Taraf bukti, bukti standard, standard pembuktian. Apa bukti okay, in certain case. So after deciding who has the burden of proof, we have to consider what standard is required to discharge the burden. The question of standard of proof required only comes into play once it has been determined who has the burden. Siapa yang ada burden tu? Okay, the standard of proof is the level of proof required in legal action to discharge the burden of proof, that is to convince the court that a given proposition is true. Okay. Typically, most countries, as mentioned just now, there are two levels of proof, namely BOP and BRT, balance of probability, as well as beyond reasonable doubt. For civil case is BOP, balance of probability, and for criminal cases is beyond reasonable doubt, not beyond shadow of doubt. Reasonable doubt, beyond a reasonable doubt. Okay. So far semua okay ke?
Okay.
Okay, that's good. Tapi kan bergantung juga. Ada certain country tu dia buat the different kind of burden. Okay, but basically it's same lah. BOP, they only use different terminology like irresistible conclusion test, apa tu? Okay. Some country in the US they use the word uh, reasonable women test. Okay. Okay. Beyond reasonable doubt. Okay. Beyond reasonable woman test. Okay. That kind of things lah. Okay. But basically it's either BOP or BRD. Okay, I just want to give few example about standard of proof in certain situation. Macam everybody are talking about election in Sabah. So in case there's some offence being committed, what is the quantum required to prove election offences? So kita ada Election Offences Act, right? 1954. Okay, keyword. Apa dia punya quantum? Keyword dah pakai pun, offences. Offences selalu relate dengan criminal lah. So criminal standard lah, which is beyond reasonable doubt. Okay, criminal standard. Kita ada case Wong Sing Nang against Tiong Tai King, 1996, 4 MLJ 461, and the case of Ri Pengkalan Quarter by election, 1981, 1 MLJ 265. Okay, so that's it, election offence. How about if the case is depend wholly or substantially, keseluruhannya atau kebanyakannya kes tu disokong oleh bukti-bukti yang berdasarkan keadaan circumstantial, tak ada documents, tak ada witness. Okay, apa dia punya standard of proof? Standard of proof dia BRD lah, beyond reasonable doubt. Okay, ataupun some court use the terms irresistibly conclusion test. You refer kepada kes Datuk Mokhtar Hashim against PP 1983 to Melayu Law Journal, case of McGreevy against DPP 1973, One Weekly Law Report, and the case of Kim Seong against PP 1968, okay, 1 MLJ, and the case of Syed Muhammad Faizal bin Syed Ibrahim 2004, 6 Melayu Law Journal 302. How about contempt of court, menghina mahkamah? Okay. Contempt of court is an offence of criminal character. A man has to be sentenced to prison for it. It must be satisfactorily be proved lah. Okay. To use the time honoured phrase, it must be proved BRD, beyond reasonable doubt. Okay, you refer pada Ri Bramble Limited 1970 Century and the local case of Lee Lim Huat against Yusof Han. Okay, 1977 to MLJ. How about fraud? In the past, the rule ni selalu bawah. Okay, in the past, okay, the court argued that the distinction between civil and fraud cannot hold. Okay, before this, the court is depend on fraud because we have a civil fraud, we also have a criminal fraud. Kalau civil fraud tu maknanya standard of proof is BOP lah, balance of probability. Kalau criminal fraud would be BRD. So depend on type of fraud. Then the court say later on, by virtue of the case of Eric Chan, Tiam Soon against Sarawak Securities Yang Berhad for 2000 for CLJ, and the case apa lagi? ASEAN Security Papers Mills Yang Berhad against CGU Insurer Berhad 2007, and the case of Yong Ting against Hok Hok. Okay, said that it's very hard to distinguish between civil fraud and criminal fraud. So the court has agreed through all the cases that in such situation the standard of proof must be uniform lah, which is BRD, beyond reasonable doubt. Beyond reasonable doubt. Okay. But again, the rule change berubah. Okay, latest in 2015, 5 years ago, kita ada case Si Nayah and Sons Yang Berhad against Damai Setiausaha Yang Berhad. The federal court decision which lowered the standard of proof in civil fraud claims, okay, from beyond reasonable doubt to a balanced probability. So it lowered the standard of proof lah. Okay. So kalau fraud for civil case, balance of probability. Kalau fraud for criminal will be beyond reasonable of doubt. With this decision, Yong Ting tadi dengan Ang Hiok Seng tadi have ceased to be a good law in Malaysia. Okay, and not only that, okay, we are now follow our line together with the legal position took place in England, Australia, as well as Canada. Okay, with regard to the standard of proof to be applied for fraud in civil cases. So I give you example of cases. Okay. In English, okay, Canada, okay, as well as Australia, as well as not forget Singapore also. All these jurisdictions have a similarity in terms of standard of proof, okay, to prove Apa tu? Fraud in civil case, it must be based on balance of probability. Alamak, siapa pula yang pergi tekan ni? Kena download balik. Hai. Upload balik. Upload. Tekan balik one by one. Start lagi. Dan begitulah seterusnya. Okay, so we are here. Fraud. Okay, so starting from this case to prove fraud in civil cases, the quantum of proof is on balance of probability. Okay, so in other words, we are following the position taken from other jurisdictions like England, Australia, Canada, and including our close neighbors Singapore. Okay, balance of probability for civil cases. Kalau criminal, BRD lah, beyond reasonable of doubt. Beyond reasonable doubt. Fraud and forgery is two separate things. Kalau case forgery tu apa standard of proof? The standard of proof required in case of forgery on the facts of such case is one before the court is not a beyond reasonable doubt but on balance of probability. Okay. You refer to the United Bank, Asian Bank against Tai Sung Hang Construction, Syarikat Islamiah against Bank Bumi Putra Malaysia, and Bunsun Bunyanit against Adona Property. Okay, yang berat Tapi tak tahu apa dia current position Tengok juga current position ni. Okay, what we have learned is not fixed forever It's subject to changes. Okay. Kena check juga. Alibi, if there's an allegation of particular facts to rebut the fact, quantum of proof is on balance of probability. Tadi someone sister said, kalau case defense tu criminal, dia tak ubah-ubah kan. Kalau prosecutor, they must prove the case on BRD, beyond reasonable doubt. Kalau defense, they put out a defense macam alibi, it's on balance of probability lah. Okay, that's why we discussed just now, for legal burden, it's not shifted. Okay. You refer pada case Datuk Mokhtar Hashim tu. And section 103 of the Evidence Act. Kalau self-defense, defense kan. So the quantum of proof, kalau defense sama ke dengan prosecutor? Tak sama lah, prosecutor je beyond reasonable doubt. Kalau self-defense, defense yang put forward, then the quantum of proof is on balance of probabilities lah. You refer kepada section 105 tadi. Okay, itu dia. And the case, as I said, you refer case Jayasena against R lah, 1970, appeal cases 618. Okay. Kalau case matrimonial offences macam mana? Jenayah dalam rumah tangga ni. Adultery, cruelty, desertion. Okay. So, nama pun offences. So, the quantum of proof offence selalu criminal lah. Mana ada offence dalam civil. Okay. Itu liability apa dengan civil. Okay. Offence. So, the quantum of proof is high lah. BRD, beyond reasonable doubt. Okay. You banyak case boleh refer. Lim Yung Yin against Gan Kim Biao. Okay. And banyak lagi. Wee Hock Guan against Chia Chit Neo. Itu dia. So we finish with the concept, burden and standard of proof. Now we move to the last part of our lecture series on prima facie case. Okay, so prima facie, what is the prima facie? Okay, yang ini kita dah belajar itu sikit delivered by Mr. Ravi Niko. Okay, from Hakim Arabi okay, on 23rd July 2020 So those who tune in, they know lah tak semua orang tune kat sini ada tulis 84 orang je. So kelas saya ada 95 orang, 9 orang tak datang. Okay. Okay, itulah dia. 9 ke? Matematik ada 11 Sorry, 11. 11 orang datang. So those who attended, they will know lah what is prima facie case. So dalam kes-kes jenayah, civil tak ada. Okay, kita kena, dia ada 2 layer, okay, to bring an action against accused. One is to prove a prima facie case, another one is the actual case. Okay, itu ada 2 layer. Okay, prima, bawa buktikan prima facie case dulu. Dah ada bukti prima facie, barulah masuk proceeding penuh. Okay. So kenapa kita kena fokus on prima facie issue? Okay, I relate to the current hot issue of the days lah, involving the former Prime Minister. I think you all come across right, last year dalam bulan November tu right, masa kita tengah belajar evidence part 1 tu. Okay, the court rules that, the High Court ruled that there enough evidence of a prima facie case against the former Prime Minister lah for the SRC trial lah. So he been called to put up a defence. Okay, put up a defence. So put up a defence maksudnya dia ada tiga step yang accused ni boleh put forward. Apa yang Mr. Ravi cakap tu? Number 1 apa? What kind of a defence they can put up? What way of our defence? Apa? Pertama is apa? Untuk memberi keterangan bersumpah. Kedua, keterangan tidak bersumpah. Dan yang last kali, ketiga?
Berdiam diri.
Berdiam diri ya. Yang mana punya nilai yang paling tinggi sekali?
Keterangan bersumpah.
Kenapa bersumpah tinggi? Suhaili?
Sebab menunjukkan benda tu confirm.
Yes, correct. Logic, yes.
Okay.
Sebab sumpah kan? Macam dulu kita belajar corroboration, kenapa unsworn testimony of a child is lower compared to sworn testimony of a child? Kenapa unsworn ada 133A? Sworn pula tak ada matter of practice je, right? Because unsworn is lower in terms of its value compared to sworn evidence of a child. Kalau sumpah maknanya ada value, nilai yang tinggi. Okay, so dalam kes SRC-nya, kalau you baca fact dia betul-betul, kalau you go through, okay, the former Prime Minister decided to give sworn testimony in court, right? Okay, sworn testimony in court. Okay, itu dia. You can refer to my short article on this topic, written in Malay, or at Astro Awani, dated 11 November 2019. Because banyak orang-orang layman kat luar sana, layman, okay, some of student also, kalau kata ada prima facie case, maknanya bersalah lah. No, it's not true. Okay, having a prima facie case does not mean you are guilty. Okay, it's only that there's enough convincing evidence, okay, being put forward against you for you to set up a defense. Okay, itu je. It's not that you're guilty. To put up a defense. Okay, tu saya said artikel dipanggil bela diri tidak maksud bersalah. Saya dah bagi dah dekat Syami dengan Syauqi, so deliver kat you. Okay, tak tahu dapat ke tak. Okay, so boleh refer lah. I just put it simple aja. Okay, just a 2 paragraph. Okay, so can refer to my short article on this point lah later on in Malay. Okay, in criminal case, the first thing the prosecution has to do is to prove a prima facie case. And if this is proven, then they have to prove their case beyond reasonable doubt. Itu dia. Ada 2 layer. Satu prove prima facie case, then prove their actual case lah, the full case. Okay, fulfilling the quantum of beyond reasonable doubt. Asal beyond reasonable doubt? This is criminal. Okay, as Mr. Ravi said last time during the talk, for prima facie is a criminal case lah. It's not civil, right? Okay, but there are some jurisdiction, I don't want to say to Ravi last time. Okay, there are some jurisdiction we also extended requirement of prima facie for civil cases. Okay, I noticed in some state in the US, okay, they also require to prove prima facie case for civil cases. Okay, so never mind lah, that one is different issue. Okay, just to highlight, prima facie is basically Latin for means that on the face of it, on the first glance of it, it's a case. Itu dia. Okay, on the face of it, on the first glance of it, there's a case against you. So please put up your defense. Itu maksudnya. Prosecution has to produce evidence to prove every ingredient of the offense, which is if defendant failed to explain, okay, we'll put him in he or she being found guilty. Example, Ali was arrested for theft. Okay, mencuri. Ali, after a police investigation, there was enough evidence to charge Ali in court. Ali decides to claim trial. The prosecution opened their case, and at the close of their case, the judge decided that there is a prima facie case against Ali. Okay, Ali is directed to present his defense by sworn testimony from the witness stand, where he will be subjected to cross-examination process, by sworn statement from the accused dog, or just remaining silent. Okay. At the end of the trial, the judge considered the evidence put forward by the prosecution and Ali's defense. Okay, the judge decided that Ali's defense does not make sense, and the prosecution has proven the case beyond reasonable doubt, and Ali will be sentenced guilty for theft. The judge will sentence Ali to jail. That's the process. You nampak tak? Macam case former Prime Minister, he's decided to give sworn statement in the council. But even though sworn statement, the High Court still find he's guilty . Okay, maknanya statement dia beli tu masih lagi tidak create a doubt towards the allegation put forward to him . So it's the court view . Okay, it's very hard for us to to say on the other way. Okay, itu dia. You cannot ask me So what do you think? I have no idea. Okay, bahaya. Susah nak komen sebab kita ada prinsip contempt of court, right? I just watched direct telecast from Parliament just now, TV1 RTM They said they're trying to propose specific act on contempt of court in Malaysia. Currently we don't have a specific act on contempt of court, so they're trying to propose. Okay, so is it good to have an act or not? It's up to everybody . Okay, this . Okay, come back to our talk on prima facie case. Okay, it will be the judge's duty to decide after prosecution has finished presenting their case whether or not they have managed to establish prima facie case against the defendant. If the prosecution managed to prove such a case, the court will ask the defendant to present their defense . If the prosecution failed to prove the case, the court will discharge defendants. Okay, clear of all the charges. Okay, itu. So dia. Last question for my subject. Not last question of the day. Last question for my subject. Lepas ni tak jumpa lagi dah muka ni. Okay. What is the criteria which need to be satisfied for the finding of prima facie case? This what Mr. Ravi tried to explain. So I just summarize criteria. Criteria maksud dia quantum of proof. Okay. Dalam full proceeding dia kena prove the case beyond reasonable doubt. Macam prima facie case, apa quantum dia? Okay. Siapa yang datang itu dia dapat tangkaplah sikit-sikit. Mr. Ravi ada refer kan kes ni. Ho Tua Tau. HTT. Tu je. 1981 to Melayu Law Journal 49. The court undertake minimum evaluation of evidence to constitute a prima facie case. So the court used the terms minimal evaluation. The court didn't use the word balance of probability or beyond reasonable doubt. I don't think balance of probability is an issue here. Okay, because it's a criminal case, there cannot be a balanced probability punya arguments. Okay, then the court referred to the case of Koh Hee Chiang against PP. Okay, as I mentioned atas, they have a different school of thought on this particular point. Normal lawyer, dia banyak dia punya school of thought. Okay, itu dia. Koh Hee Chiang against PP. Okay, 1994, 1 Melayu Law Journal 265. The duty of the court at the end of the prosecution case is to undertake not a minimal evaluation of the evidence standard by prosecution like Ho Tua Tau case, but maximum evaluation of such evidence to determine whether or not prosecution has proved their case against the accused beyond all reasonable doubt. Beyond all reasonable doubt. Okay, so they make a reference. Okay, these are the court say on the first part that it's not minimal evaluation like Ho Tua Tau said. Okay. But it's a maximum evaluation. What do you mean by maximum evaluation? Okay, something against the accused beyond all reasonable doubt. Sama macam full proceeding tu. Another case, in the case of PP against Ong Cheng Hiong, 1998, from Current Law Journal 209, where the court took maximum evaluation again. Macam Koh Hee Chiang. on the evidence, but did not associate it with the beyond reasonable doubt. Koh Hee Chang, they associate with beyond reasonable doubt, but in this case, Ong Cheng Hiong, dia tak associate it. Means that it's little bit lower lah, tak perlu tinggi sangat. Okay, and similar in PP against Datuk Seri Anwar Ibrahim, DSAI, Augustine Paul said that, insists that the case should not be called as a reasonable doubt because the term is more aptly used at the conclusion of the whole trial. Okay, beyond reasonable doubt is not to prove a prima facie case because it's only a prima facie case to know whether you put up a defense or not. Okay, okay, beyond reasonable doubt is only reserved specifically, exclusively for the full proceeding later on after you have after you have managed to prove a prima facie case. Okay. Another case, banyak case ni. Okay. Loy Koh Chai against PP 2003, 1 Current Law Journal 734. The court shall examine the evidence of the petition rigorously and held that the standard to be applied on the evidence was on maximum evaluation test, not beyond reasonable doubt. And refer to the case of Balachandran. Nanti Ravi dah refer dah ni. Itu against PP 2005 to Malayan Law Journal 301. Federal Court highest court in the land level. It said that avoided from using the term maximum evaluation. Instead, they use the term positive evaluation. Okay. Worth to know that positive evaluation is rather similar to maximum evaluation lah. Macam tadi kan, irresistible conclusion test. So maksud dia, beyond reasonable doubt. Tu je, okay? Okay, some judges, they're too creative like me. Okay, they like to create their own terminology. Okay. Positive evaluation. Is it okay semua? Boleh faham ke? Ni I summarize apa yang Mr. Ravi cakap itu. Sekejap je. Okay ke?
Okay.
Okay Sally
Okay saja.
Okay, that's good. Okay guys, Alhamdulillah, with that we finish our law of evidence entirely. Bye. Habis dah. Okay, not bad Dapat juga kita habiskan. Alhamdulillah, we finish law of evidence subject.
Kita akan ada one last tutor, Doktor kan?
Apa dia?
Kita akan ada one last tutor lagi kan? Yang
Tak ada, tutorial finish last week.
Yang tutorial question 7 ni untuk
Question. Kita bincang lepas ni.
Oh, okay.
Directly. So this is law of evidence is all about. Okay, so last semester recap back what you have learned. We've learned about introduction, like what is Evidence Act, where is it come from? Okay, it's a combination of British colonial and the local custom. Okay, then we have learned about okay, so top priority should be given to our Evidence Act lah. So anything will relate to evidence or anything relate to procedure lah. Next semester you're going to learn about criminal procedure, civil procedure. Okay, you should refer to our statute. And we learn about the evidential concept, right? Evidence standard must be relevant. No point. It's okay. Makes no point submit so many evidence if it's not relevant lah. Evidence standard, okay. Illegally obtained evidence. Okay, the court is not bother how the evidence is obtained as long as it's relevant to your case. Okay, hearsay evidence. You say something based on what you hear. Okay. Okay, so what is the value of this evidence? Is a weak evidence. It's a piece of evidence, but weak. Okay. Sometimes we can accept it. Under what category we can accept hearsay evidence? When it fall under exception lah. Dying declaration, res gestae, section 6. Okay. Your house is burning and you're running away? Ingat tak kisah? Kes apa tu? Tapper. Okay, written. Okay, itu dia. Relevancy section. Okay, we've talked about so many. Everything is a relevancy section lah. Okay. Motive. Okay. Circumstantial evidence. Okay. Conduct. Okay, character evidence, okay, that kind of thing. And we have a similar facts evidence also. Okay, case apa tu? Makin, Botman, DPP against P. Okay, admission and confession. Both admission and confession must be voluntary. If not voluntary, then we cannot accept it. Okay, expert opinions. Okay, so expert testimony. Okay, so section 45, anybody can become expert, but only court should rely on expert opinion in 4 areas lah. I hope you still remember apa 4 areas tu, macam science, teknologi semua tu science, okay, finger impression, international law, okay, another one is what finger impression, international law, science and art, handwriting. Yes, handwriting, tulisan. Kena panggil expert. The court cannot give his own opinion. The court can only give its own opinion if it fall beyond the 4 mentioned category under section 45 lah. That would fall under judicial notice. Okay. And of course, today we have, this semester we have learned about the mode, how to authenticate evidence. Okay. So now you have learned. Okay. Documentary evidence. Okay. Presumption. Okay. Aduh. Okay. Corroborations. Estoppel, privileges, examination witness, and today our topic burden and standard of proof. Okay. Okay, last tutorial question. Let us go through the concept burden of proof divided into 2 parts. Examine this further. Apa 2 parts tu? Ada siapa boleh jawab?
Beyond reasonable.
Evidential burden and legal burden.
Yes, correct. Evidential burdens and legal burden. Yang beyond reasonable doubt dengan beyond probability tu quantum of proof. Okay. Ini burden of proof. Okay, not quantum of proof. Okay. Okay, number 2B. Ada siapa boleh baca for the last time untuk I?
Me.
Baca Filzah, Hendon.
Basay, in his evidence in court, stated that on 12 February 2020, he returned home after work at 9 p.m. and saw Ahmad running out of his house. Then on checking the house, Basay found a sum of 3,000 was missing from a cupboard where he keeps his valuables. However, in his police report, Basay stated that on 12 February 2020, when he come home from work at 7 p.m., he saw Ahmad running out of his house. Upon checking his cupboard, he found that a sum of 3,000 was missing due to some differences between the testimony given in court and in police. Tak nampak ni.
Tak nampak bawah
The police report will be possible to impeach the credibility. Tak nampak rasa?
Sebab dia ada tu kan, ada apa kita panggil dia?
Yang
Instruction.
uh-uh.
Impeach dia apa yang tulis tu? Aku tak nampak. Impeach apa
The
tu?
credibility Basay.
Credit of Basay.
Credit
Yes.
Aduh, susahnya. Okay, credit of Basay. Analyze this issue Yang ini yang last week kita bincang kan. Dalam court testimony dia kata apa? Running out from his house at 9 p.m. right? Basay found 3,000 was missing But however in police report, same date. But only different time. 7 p.m. Okay, he saw ada seorang running out from his house. So the issue now, okay, can we still accept the testimony given by Basay in court? Should we impeach? Dia kena soalan dia. Should we impeach So what do you think guys? Ada siapa yang bagi jawapan? Just because of this. Kenapa perlu impeach?
Because inconsistency with former statements.
Authority? Suhaili?
Section 155C.
But Suhaili, kita ada case of Mutusami tu. It's mentioned that inconsistency should be a serious inconsistency. Minor inconsistency is okay. Dapat tak Suhaili?
Dapat. Okay.
So what Suhaili say is okay lah. Okay. Kalau ada inconsistency, by rights we can impeach, singkirkan saksi dari mahkamah. Tapi what kind of inconsistency? We have a case of Mutusami to highlight section 155 proviso B, C, sorry. Okay, inconsistency means it must be a serious kind of inconsistency, not a minor kind of consistency. Kalau you look back at our case, dia cuma ada gap 2 hours je. Asalkan benda tu berlaku malam, okay. Tapi it's very hard for me to say lah whether this one is serious or not. It's up to the court. It's up to you, for you how to argue this, okay. I will not say. But as long you argue within the ambit of law, is correct lah. It's 155 proviso C tu. Okay, ada inconsistency whereby you have a right to impeach a witness. Okay, whether the court should impeach it or not is up to the court lah. Itu dia. What kind of impeachment? Inconsistency must be a serious kind of inconsistency of a statement being given by the witness or the suspect. Itu dia. Boleh dapat ke semua?
Boleh.
Okay. That's good.
Doktor.
Yep.
Formal statement tu mesti FIR je ke? Statement tu boleh juga kalau statement of defense.
It can be anything.
Okay.
Ada report je. Dia boleh statement make to a member, WhatsApp ke, phone call pun boleh.
Okay. Thank you, sir.
Most welcome. Can be oral, can be written, can be sign language. Okay. As well. Itu dia. With that, we finish with our tutorial question. Okay, our last tutorial question. Okay. Finish with simple aja. Okay. Which topic to focus for coming final exam? Perlu jawab ke? Perlu saya bagi tahu ke? Rasa you all dah tahu kan jawapan?
Semua.
Terima kasih Firza. Senang. Itulah. Susah lah nak separate one point to another point, okay? Alah. Ya.
Yang midterm punya hari tu tak masuk kan?
Macam mana nak separate because it's interconnected, sister.
Okay.
It's interconnected. Yang sem lepas pun ada juga. Yang tu relevant.
Okay.
It's interconnected. Yang kata sem lepas, ayat itu topik-topik lain yang you belajar dekat subjek-subjek lain pun masuk juga. Bonsium Binanit, Land Law, masuk juga kat evidence. Law of Thought, apa you belajar? Raja Razif dulu ajar, Beyond the Visible Doubt, masuk juga kat evidence. Okay. So it's a very universal punya subjek. Very, very universal. So tak ada strict sangat lah. Baca topik ni je tu. Topik ni saja. Tak boleh baca yang lain. Okay. Okay. Lah, take home test pun. Okay. So evidence tool final exam will be on 19 and 20th August 2020. Question and answer will be done through goals application. Please make sure you're able to access to goals applications lah. I hope everything's okay lah with this goal application. Tak tahu nak buat apa. Pening lah. Okay, goals applications. Ada apa soalan ke pasal goals ni? Ingat nak masukkan dalam ruangan assignment. Lepas tu you jawab, you type. Lepas tu you convert balik pada PDF, hantar balik pada I. Itu je. Dia. Supposed to be like that lah. Macam midterm kita senang je kan. Okay. I will try my very best to release the carry mark result before final exam lah. Okay. 70 marks lah banyak tu. Maknanya kalau korang dah dapat 50 ke 60 dah kira pass lah tu. Isu dia dapat A ke tak. Okay. Okay. So assignment, midterm test apa? 45 markah. Assignment 15. Then you punya participation tutorials, that will be 10 lah. And 30 mark final exam. Apa soalan?
Sir. Jawapan kan macam cases kan? Nak highlight ke warna kuning macam tu boleh?
Boleh buat macam final exam lah, kenang-kenangan.
Highlight lah guna words kan?
Sebab you dah boleh type kan, boleh type, so macam-macam mekanisme ada kat komputer tu. So pergunakanlah mekanisme yang ada kat komputer tu untuk highlight ke, nak buat bintang ke, nak buat garisan ke. Tapi jangan pakai warna gelap lah, aku tak nampak lah. Ada yang lebih kreatif kan, dia highlight pakai colour warna hitam. Bukan aku nampak sebab dia cat warna hitam. So make sure I can see case apa tu, section berapa. Okay. Logic and common sense kalau nak highlight pun. Okay, make sure I can read it. Make sure you can read it. Itu dia.
Alright, sir.
Itu je lah. Jangan buat bunga pula lebih-lebih pula kreatif. Bunga tu tak kena markah tu. Bunga ke gambar kartun ke apa. Okay. Ada apa-apa soalan lagi? Semua okey ke?
Sir.
Ya.
Nak tanya pasal final exam nanti struktur soalan tu macam mana ya?
Ada 2 soalan je. So, satu soalan 15 markah. So, 2 30 markah. Jawab dua-dua.
Jawab dulu.
Okey. Itu je. 2 soalan je 30 markah. Simple je, simple.
Problematik sah?
Problematik. Macam midterm itu kan ada teori, ada problematik. Macam tu juga. Ada teori, ada problematik.
Jadi satu soalan ada pecahan soalan ataupun satu soalan besar tu sir?
Satu soalan ada pecahan.
Alright. Okay. Okay sir,
Sikit.
thank you.
Most kan tak banyak pecahan dia, sikit je. Sikit. Nothing to worry lah, 2 question je. Yang I worry satu je, okay? Takut tak dapat, I tak dapat upload soalan tu dalam my goal system, you pula tak dapat. I risau itu, I takut sistem je. Okay, yang lain semua tu aku tak risau sangat. I tak risau pun you boleh jawab. I rasa semua boleh jawab ni, no problem. Okay, I cuma risau sistem je sebab diorang suruh kita melalui sistem ni. Ikut hati aku malas je. Nak hantar melalui WhatsApp je macam ni. Okay, tu. Sebab they want to ensure that nobody can cheat tu je. Okay, as much as possible. Cheat mean maknanya exchange of question between the student lah. Okay, no cheating ya. Make sure no cheating ya. Jangan copy paste from your friends ya. Kau tak dapat jawab, kau pun 2 kali 5 tak dapat jawab. Okay, kalau ada jawapan yang sama, then I can presume, okay, is a copy paste lah. Okay, so jangan copy paste among members. Use your own word. Okay, English berterabur pun berterabur lah. And don't copy paste from my notes lah, for God's sake. Aku muak baca nota aku. Okay, use your own, okay, sentence. And every case, authority case section you must explain lah. You don't just give the name of the case and without explanation. Okay, itu dia. Okay, so this will be our experience lah having a long distance exam. Okay, midterm test ya. So far seorang je yang tak hantar lagi ni. Hadri ya, tolong remind kan you punya best friend ni. Okay, BFFU Okay, suruh hantar dia KLB2 remind sekali lah. Okay, dia seorang je tak hantar assignment. Apa problem dia aku tak tahu lah. Okay, remind him to send assignment. Boleh? Okay.
Betul. Hadri dah hantar.
Apa dia?
Hadri dah hantar.
Tak dapat pun? Bila?
Sebab kita orang cek hari tu dekat Google dah ada dah dia punya nama.
Hari hantar Google nama dia? Oh, okay.
Dia tak hantar case review je kan doktor kan?
Case review, assignment dia hantar. Midterm dia hantar. Case review saya tak nampak pun.
Okay, case review memang dia tak hantar lagi.
Betul lah. Assignment dia hantar. Case midterm dia hantar. Case review. Yang masukkan ni case review. Faiz. Submission dia.
Sorry doktor. Nanti saya ingatkan dia.
Assignment je.
Okay doktor.
100% submission of midterm test, 99 assignment. Kan tulis kat sini, 100% submission of midterm test, 99% assignment. 99, okay, 1% tu dia lah tu. Okay, so tolong ingatkan dia Faiz ya, tolong hantar assignment, hantar je, apa susah.
Baik doktor.
Sama. Mana dia? Okay, tu je.
Okay.
Banyak markah tu, 15 tu. Alamak, hang, tak habis hang. Okay, I think that's all lah, okay. By the way, thank you very much for attending all the talks organised by me for you. Okay, ingat lagi tak last semester BTO how to be a good soft skill lawyer, right? Okay, And apa ni, ingat lagi tak merit Peter before PKP? Sempat kita buat sebelum PKP dulu. Oh okay. Okay. Sempat merit Peter. So I hope you enjoy. And then dah PKP zaman baru, normal baru, semua online. Tuan Faizaluddin Okay, differences between evidence Act and Syariah punya evidence Act. And not to forget Prima Facie by Ravi Nico. So thank you very much for your support and cooperation for our talk. So I hope you enjoyed so much. Okay. Simpanlah kenang-kenangan. Dah tak ada lagi. Okay. And thank you very much. Okay. Masuk news. Siapa ni? Okay. Ni Riaz. Syauqi. Okay. Glamour dia. Tata cara komunikasi peguam. This is good lah. Okay. I can highlight to Bar Council when they make a second visit to our faculty later on. So that's good. It's good. I like it very much. Okay. Komunikasi. So as a lawyer, my advice to you, lawyer to be, make sure you have a good communication skill. Okay. No point you have so many knowledge, but you don't know how to talk to people. Talk is one thing, but talk to people is another thing. Okay. Okay. So try to improve your soft skill communication. Soft communication skill. Okay. Okay. How to speak to people? Speak nicely. Don't speak very harsh. Okay. They are your client. Okay. Treat your staff in a good manner. Respect each other. Okay. Itu dia. As much as you can. Okay. Don't insult people. And thank you for attending a special talk also. If you still remember last year. Ingat tak? Bulan Disember dulu. By Mr. Ramesh. Okay. Topic of examination process of a witness. Okay. Of a witness. Okay. So interesting lah. So I might invite him again lah to give a talk on examination process of witness. Boleh join lah. Nanti you final year pun you boleh join. No worry. I make it open. Okay. Hai. Sedih dah nak habis ni. Alah. Malas lah benda macam ni. Stuck. Ni yang nama dia stuck sister. Kena upload balik. Bengang sister. Bila nak habis ni sir? Dah 12.30. Apa aku nak buat? Komputer rosak. Ada apa-apa soalan setara nak tunggu benda ni improve balik? Boleh tanya apa-apa last time lepas ni tak ada dah. Sekarang soalan di WhatsApp tak akan dilayan. WhatsApp.
Sir.
Ya.
Sir tak nak jumpa kita orang ke?
Macam mana nak jumpa tak boleh gathering sayang? Sayang tak boleh jumpa gathering. Tak dibenarkan. Okay.
Okay.
Tak dibenarkan. Nanti kan kena tangkap semua kan.
Okay.
No gathering, no large gathering. Permitted. Tapi universiti open kan nanti kan bulan Oktober kan? Kan Diana?
Dah finalize ke saya? Boleh masuk USIM? Bukan subject to change
Setakat ni I was informed untuk semester ni online je. Next semester dah boleh face to face lah.
Oh. Okay.
Tapi terpulang kepada budi bicara pensyarah masing-masing lah. Sama ada lepas ni nak buat face to face ke ataupun nak online sampai kiamat. Tapi rasa-rasa macam semua nak ketagih guna online ni, faham je lah kan?
Okay, thank you.
GKS kita tu bakal menjadi museum. Sebab semua dah macam ketagih ni. Macam I nanti kan next sem kan, I mungkin kelas lah face to face. Tutorial tu saya nak buat online. Okey tak? Untuk budak yang akan datang.
Sir, nanti kalau ada lawatan nak join.
Lawatan korang tak dapat. Sorry lah, tak dapat.
Saya je nak join.
You je.
Alah, nak ikut.
Orang dapat A boleh join.
Alah, Su.
Sedihnya, batch korang tak dapat pergi. Sorry lah sebab kesihatan.
Buat lagi doktor.
Ha?
Saya buat paperwork.
Apa pula aku, so budak batch akan datang lah.
Eh,
I hanya pengikut je, pengiring. Pengiring. Kesian korang tak dapat pergi ya. Tapi tak apalah, apa nak buat. Kesihatan dan keselamatan lebih penting. It's unpredictable kan. Kita sangka kan benda ni berlaku kan. So, can't do anything lah. Okay. Mana slide ni? Sorry lah, banyak sikit slide ni sebab last day kan, 60 slide. Oh, okay. Okay, so orangnya tak ada tapi tak apalah. Kita bagi special appreciation to Syami and Syauqi for being a very wonderful and hardworking class monitor. Tepuk tangan semua. Syami tak ada hari ni. Dia kata dia terpaksa jaga budak-budak Tamidi. Okay. Okay, so thank you very much Syami ya. Okay, nanti dia buka balik rekod. Okay. Thank you very much Syami ya. Very very wonderful good job you have done. Very really appreciate and Syauqi also banyak kerja dia buat tu Okay. Nanti jam dia warna merah Next. By the way, who shall I appoint class monitor for next batch? Any idea ke?
tak kenal lah doktor dia orang.
Hai, adik junior tak kenal? Adik junior tak kenal. Aduh, hai. Teruknya korang.
Tapi doktor, kalau famous tak semestinya buat kerja tau doktor.
Betul, tepat sekali. Kalau famous tak erti buat kerja.
So
kalau handsome pun juga kan?
Kalau handsome maybe boleh.
Terkejut ai. Terkejut ai, tergelak Diana. Terkejut. Okay, by the way, who should I appoint Tengoklah siapa yang volunteer berserah je lah. Berserah. Adalah. Okay, my last point Thank you very much for all your support and cooperation given I deeply appreciate I wish everybody the best for the coming final exam and your future undertaking lah. I apologize anything I said which is wrong, which is very hurtful whatsoever. I'm a human being, so I'm not perfect lah. Okay, so I apologize if anything I said hurt you feeling anyway. So thank you for your support. Thank you for your cooperation. Okay, so wish you the best. Okay, don't forget me. Okay. And this is my latest textbook publication. So if you are interested, you can purchase Malaysian Legal System 2nd edition. I make a first edition 4 years ago. The CLJ publisher tahun ni 2020 last month in June 2 months ago in June price 270 1200 pages Malaysian Legal System ni kat mana ni sir? Kedai buku Kinokuniya, KLCC. Tengok buku sendiri. Okay, it's not only my work lah, it's contributor from many people My former lecturer from UIA Prof Datuk Dr Ashgar Ali, and we have Prof Syam Rahayu. We have siapa tu former Chief Justice Ketua Hakim Negara tu bukan Tun Zaki bukan kan, no, siapa tu Abdul Hamid Muhammad. Okay, also contribute his idea. Okay, so ada civil procedure topic dalam dia, ada criminal procedure topic dalam dia, relevant to your punya discussion for next semester Okay, CP dengan CPC. Ada juga professional practice. Okay. So if you are interested, you can purchase. Okay, this latest textbook. So pergi kedai buku pun pakai top, boleh tutup muka, kena tangkap lah. Itulah dia. Okay, thank you everybody Thank you and stay safe lah
Doctor.
Yep.
On behalf of KLB1, I would like to express our gratitude for teaching us for this whole 1 year daripada tahun 1 and minta maaf kalau ada kurang di mana-mana.
Okay, so nice. Thank you so much Filza deeply appreciate Okay, on behalf of KLB1. Okay everybody, dah 12.30 dah, hampir 12.30. So thank you, stay safe. Bye bye.
Thank you too sir.
Bye, tak jumpa lagi ai.
Jumpa kat Bullet sir.
Okay, good luck final exam Apa-apa hal WhatsApp ya.
Okay.
So tak dapat soalan Okay. Okay. So dah dapat answer script. Okay. So tak apa, yang itu boleh jawab. That kind of WhatsApp I boleh entertain. Okay. Okay, good luck. Bye everybody. Pergi lunch. Semua stay safe ya. Sekian salam yang tak datang today ya.
Syahmi ke?
Thank you, sir.
5 orang tak datang ni. Bye.
Okay, bye sir.
Bye Adib. Okay, bye Azim. Okay. Bye Irfan, Ain Farana, okay, Alia, Fatin, Filza, Kauza, Faiz, Ashraf, Muhammad Fauzan. Okay. Okay, lukis balik gambar kartun. Okay. Azhan, sabar kena kau. Itu Sarawak, sorry. Undi siapa kau? Okay. Muhammad Alif Imran, Muhammad Aiman, Muhammad Amirul, Wafi, jaga kesihatan. Okay. Nazira, Nur Amira, Nur Akila Asmida, bye-bye. Atira, bye-bye. Dayana, okay. Nur Farah Aina. Nur Hijrah Nur Hairul, Nur Najwa Masuk matang. Okay, so okay. Itulah dia Najwa. Siapa lagi? Najwa Nur Hanis, okay. Nurul Hasana, Kak Yan, okay. Nur Yani, binti Zaman. Arham, sihat Arham. Thank you for everything Arham Poster-poster semua. Okay. Raihana, Syakirah, Anima, okay, Syatrah, okay, Siti Fatin, thank you, okay, Siti Nur Aisyah, Wan Muhammad Akmal, thank you so much, Wan Najwa, so highly, okay, Jarif Aiman, oh, thank you so much Jarif, okay, bye-bye semua.
Bye sir, thank you sir.
Okay, Assalamualaikum.
Bye sir, thank you sir.
Bye.
Thank you sir.
Thank you sir.
Thank you.
Yeah.
Thank you sir.
Yes sir.